Okay, terrific. Welcome, everyone. My name is Doug Kaiser, and it's my great privilege to introduce today's speaker, who I've known for several years now. If you Google Ted Hamilton and you see his bios at the various places and projects where he's affiliated, you consistently find these kind of brief, modest descriptions along the lines of Ted is interested in the intersection of environmental and social justice, or Ted's been involved in movement politics and legal advocacy, or Ted studied law and comparative literature. All of this is a little bit like saying, Beyonce is interested in the performing arts. It's quite characteristic of Ted, who's one of the most genuine, gentle, and generous souls I know, to deflect attention away from himself and back onto the issues and causes that he's passionate about. But I'm going to make him endure a more fulsome and accurate description of his talents and accomplishments through this introduction. So Ted, you might want to just mute, turn off your video, get comfortable. I first met Ted in 2015 when he came to New Haven with his colleagues, Kelsey Skaggs and Alice Cherry, to talk about work they were doing as students at Harvard Law School to pressure the university to divest from fossil fuel investments. And that effort included a very creative and ambitious lawsuit that they filed as students against Harvard, alleging the institution had violated its charitable fiduciary obligations. So from that early effort to transform legal doctrine to accommodate the vast and unavoidable implications of climate change, Ted and his collaborators developed the idea of a new nonprofit climate advocacy organization that would be devoted to helping defend climate activists and supporting cutting-edge climate litigation. The organization, which is now known as the Climate Defense Project, has grown into a vibrant and impactful player in the world of climate advocacy. Indeed, the organization has played a central role in conceiving and advancing the concept of a climate necessity defense, as we'll hear more from Ted today. To be honest, I was a little skeptical of this concept when Ted and his colleagues first introduced it to me. But now I realize they were onto something deep and important about the climate justice movement and about its implications for law. They recognized that the willingness of activists to put their bodies on the line would hold a power to rattle judicial complacency. And despite initial skepticism from observers like me, the Climate Defense Project has achieved enormous success, both inside and outside of courtrooms. And as a result, I think has played an important role in contributing to the shift in public perceptions on the urgency of climate action that we've all witnessed these last few years. Now, to my great delight, amidst all of this important, essential work, Ted also came to Yale to pursue a Ph.D. in comparative literature. Now, needless to say, this is not a well-trodden path for law school graduates, but it made sense for Ted for a number of reasons. First and foremost, he is a brilliant intellectual and a talented writer with facility in numerous genres, ranging from erudite continental philosophy to more popularly accessible work like the book he'll be discussing with us today, or his numerous contributions to national magazines and other media. He's even an accomplished poet, and I highly encourage you to Google his spellbinding poem, The Marymount Constitution, after today's event. The PhD also made sense because it would afford Ted a space and a platform for critically engaging the theoretical underpinnings of what he now calls fossil law, as well as the civil disobedience movement that seeks to challenge at its core the legitimacy of fossil law. Now, to engage those kinds of questions at the deepest level, he was right to come to a comparative literature department where his theory and his praxis could be happily married without reservation or need to conform to a narrow orthodoxy. His presence on our campus during his time in New Haven was incredibly enriching for us all. He managed to serve both as a mentor to our current environmental law students and as a regular and vital participant in our Environmental Humanities program. Given the training and the experience in law, which required him to become well-versed with climate science and economics and climate policy, as well as his emergence as a sophisticated and influential contributor to literary theory, he was essentially unparalleled within our community for the ability to range across disciplinary divides and encompass the full range of ideas and approaches that are necessary to understand and to appreciate the Anthropocene. So what is perhaps most remarkable about Ted is, despite all these impressive accomplishments and talents I've just described, he is, as I noted at the outset, just a modest, gracious, warm, and wonderful person. So Ted, thank you for joining us today. The floor is now yours.
Well, thank you for that far too kind introduction, Doug. I really appreciate it. And I'm very grateful for all your years of mentorship. I think I'll just try to suppress the blushes and power through here. I'm going to share my screen. Let's see if this works. There we go. What I'd like to do is kind of just give you a very brief idea of what I'm trying to accomplish in this book, and then read a passage from early on in the book that deals with the legal saga of the valve turners, describe a little bit about how their legal effort fits into a broader conception of what we need to do with the law to address climate change and advance climate justice. And then I hope to open it up so we have plenty of time for a discussion. Very curious to hear people's thoughts and reactions. So the book is entitled Beyond Fossil Law, Climate Courts and the Fight for a Sustainable Future. And essentially the motivation and the key theme of this book, the question that I try to address is, why is it legal to continue to deteriorate and degrade the world's climate systems with all of the harms we know that flow from that degradation? And yet it is generally illegal to confront that activity, especially in the mode of nonviolent civil disobedience. The law is enlisted in suppressing dissent against the fossil fuel system rather than promoting the types of goals that international scientific consensus tells us we need to do. There are two ways that I've tried to think about these questions, this tension in the book. First, at a kind of more abstract level, I want to look at what our existing law of climate change is. That, of course, engages an encounter with US environmental law and international environmental law, dealing with the foundational concepts and possibilities of those disciplines, acknowledging how much they've accomplished, and yet necessarily asking the question of why they have not really been able to deal with the climate crisis as well as other environmental crises. What is lacking in those disciplines that has not produced the judicial or legislative recognition of the crisis that we're living through? So part of what I try to accomplish in the book is to look at the strategic and more fundamental blockages to proactive climate justice work through the legal system and through the courts. And after I read a bit about the valve turners, I want to address what I conceive as some of those obstacles. In order to give kind of a place for inspiration and hope as we confront this problem, a lot of the book also tries to deal with legal activism that has tried to solve that tension or answer the question in a way that would make it legal to try to promote climate justice goals. So ideas like the rights of nature, the public trust doctrine, environmental rights, even expansions of tort law are things that I try to engage with and think about where there's already legal activism occurring and how we can extrapolate from what advocates are already doing all around the world in order to craft a new law of climate justice that would replace the existing fossil law that has kept this system perpetuating despite all the harms that we already see around us. That's the more kind of abstract conception for us to think as legal thinkers, as advocates, as lawyers about what the problem is today and where we might go. But in my experience, as Doug kind of reviewed as an attorney for activists with Climate Defense Project, I think a really understudied area of environmental law has to do with criminal repression, the use of the criminal legal system to suppress dissent, and the ways in which activists have responded through their own types of legal activism. So one very important function of the fossil fuel system is the use of police and prosecutors to impose the use of fossil fuels, their extraction, their combustion, their control of politics, all the various manifesting ways we see the fossil fuel industry remaining in control. People confront that, and this is a crucial part of the legal struggle against fossil fuels, not what we traditionally consider to be environmental law or lawsuits against the United States to cap emissions, but trying to put bodies in the place of expanding fossil fuel infrastructure and then defending those actions in court. The main narrative through which I try to understand this aspect of fossil law and push back against fossil law involves the narrative of the valve turners, which were a group of activists who responded to a call for solidarity actions by the encampment at Standing Rock. If you may recall, in the fall of 2016, a company named Dakota Access Pipeline was attempting to, and ultimately was successful in building a pipeline across the Standing Rock Sioux territory in what's known as North and South Dakota today. A gigantic protest encampment that was the largest gathering of Native peoples in the United States in many decades, as well as affiliated allies, came and tried to block on the ground the progress of that pipeline. As part of that, in October of that year, 2016, the protest leaders issued a call for others outside of Standing Rock to put their bodies in the way of expanding fossil fuel infrastructure. And the valve turners responded by going to various pipelines across the United States that were bringing in tar sands oil and deciding to shut them down themselves. So here's just an excerpt from the book that deals with what their action was leading into their courtroom fight. For the most part, the valve turners did not resemble the most active protesters at Standing Rock, who tended to be young and indigenous. The valve turners are all white. They skew older. If you saw them on the street, you might think them more likely to host the neighborhood book club than to launch an audacious strike on dangerous energy infrastructure. As the activists have publicly noted, this profile is part of their motivation and their strategy. More insulated from the harms of climate change than most of the world's population, and less likely to bear the brunt of the legal system's racial, sexual, and classist biases, they felt a special sense of responsibility to take action. The group had come to know each other through climate activist circles in Seattle and Portland, including groups like 350.org and the Shell No and Break Free from Fossil Fuels campaigns. Some had already been arrested for protesting fossil fuels and climate policy, and all were well-versed in traditional forms of environmental advocacy. Emily Johnston, a 50-year-old poet and editor, had written and spoken extensively about global warming as a member of the Seattle climate justice scene. Annette Clapstein, 64, a retired attorney for the Puyallup Nation, had been involved in anti-war and environmental activism for decades. Michael Foster, a 52-year-old therapist, had organized climate lobbying and litigation efforts with young people for years. Leonard Higgins, 63, who began to question his middle-class values after he retired from a 31-year career as an IT manager with the Oregon state government, had devoted himself full-time to organizing in the movement. Ken Ward, 59, a veteran of mainstream environmentalism, had worked at Greenpeace, the National Environmental Law Center, and US PIRG before turning to direct action. The sense of frustration and futility engendered by these years of advocacy had set the valve turners on their path towards civil disobedience. As Leonard Higgins would later testify at his trial, quote, "Nothing was getting done, and in fact, it was getting worse. What we were doing is just a drop in a bucket. We were not getting any traction. I felt responsible to stand up for what was right. Sometimes what is right is not necessarily what is legal. It was a really hard conclusion to come to." Michael Foster, who for decades had taken every step he could to eliminate fossil fuels from his daily life, he avoids fossil-based travel whenever possible and keeps his monthly budget below $500, wrote on the group's website that, quote, "I am here to generate action that wakes people up to the reality of what we are doing to life as we know it. All of our climate victories are meaningless if we don't stop extracting oil, coal, and gas now." So the valve turners sought a more direct and immediate means of reducing emissions. If the government wouldn't stop the flow of poisonous fuels, then the activists would have to do it themselves, and without any of the powers of persuasion or coercion available to the state. They considered the measures at their disposal, they studied the vulnerabilities of the fossil fuel system, and they arrived at the same conclusion reached by generations of protesters. Their best tools were themselves. This radical reliance on principled individual action took two forms. On the one hand, the valve turners realized that many pipelines were open to quick and simple disruption. This vulnerability is the flip side of fossil fuel infrastructure's ubiquity and invisibility. As soon as we realize that it's all around us, we discover how easy it can be to turn off. On the other hand, the valve turners believed that the effect of their intervention would go far beyond the immediate decrease in the flow of fossil fuels. The activists, many of them rooted in faith traditions, saw bold action as a prerequisite to mass mobilization. In order to convince people that, with a little organization and a little sacrifice, the tide could be turned, The world needed examples of political risk-taking. This theory of change, based on a study of historical social movements, was ground up. Start with direct action, and a sense of moral urgency will in time produce the desired reforms at the top. Building on their research and inspired by interventions against Enbridge Line 9 in Canada, the group split up and traveled to sites across the West. They were concerned about Canadian tar sands oil, an especially noxious and polluting fossil fuel that flows from the fields of Alberta, where its extraction causes enormous ecological damage, toward US refineries, where it is converted into a combustible fuel source. The valve turners targeted the 4 points at which this fuel enters the country via pipeline. Emily Johnston and Annette Clapstein traveled to Enbridge Lines 4 and 67 in Leonard, Minnesota. Michael Foster went to the Trans-Canada Keystone XL pipeline in Walhalla, North Dakota. Leonard Higgins approached the Spectra Express near Coal Banks Landing, Montana. And Ken Ward aimed at the Kinder Morgan Trans Mountain Pipeline in Anacortes, Washington. In the early morning hours of October 11th, 2016, their website went live with dramatic video streams. In each state, the activists, wearing orange safety vests and work helmets, cut padlocks, took hold of safety valves, and cut off the flow of the climate-wrecking fuel. Take the action of Emily Johnston and Annette Clapstein, which you can see on this slide here. At 7:30 in the morning, under an immense gray sky and against a landscape of brown-green grass and scattered leafless trees, they cut a padlock to open a chain link gate. Ben Joldersma, filming with his phone, called the company's pipeline operations center in Alberta, Canada, and read a message. I'm here with Emily Johnston and Annette Clapstein. We're calling from Leonard, Minnesota. We're currently at the block valve sites for lines 4 and 67, just 10 miles southeast from the Clearbrook pumping station. For the sake of climate justice, to ensure a future for human civilization, we must immediately halt the extraction and burning of Canadian tar sands. For safety, I am calling to inform you that when I hang up this phone, we are closing the valves. Please shut down these 2 pipelines now for safety and for our future. Notice having been given, Johnston and Clapstein maneuvered around 2 valves that stood level with their heads and turned large orange wheels. A high-pitched whir below, like a bandsaw, signaled the flow of oil being cut off below their feet. Johnston and Clapstein placed flowers on the wheels. The site went silent. Enbridge lines 4 and 67 were down. And then the activists waited. Steve Liptay, a journalist on the scene, filmed, while many miles away, officers at the Clearwater County Sheriff's Office began receiving calls from Enbridge and the news media. By 10:30, 5 officers were on the scene. Johnston and Clapstein told them that they were protesting for an end to fossil fuels. The officers said that they respected their right to protest, but that they had to stay within the law. The valve turners responded that they'd tried that and it didn't work. Then Johnston and Clapstein were arrested and taken back to the station. This action, like the ones in North Dakota, Montana, and Washington, were precise and well-planned. As would become evident in the course of their legal cases, the group's methods posed no risk of causing a spill, and the pipeline companies were alerted before the activists turned the valves. In fact, in Washington and Minnesota, the pipeline companies responded to the call by remotely turning off the pipelines themselves. Each valve turner also carried a copy of a letter to President Obama that they had sent to the White House earlier in the day. The letter explained that the activists had, quote, tried every avenue by which engaged citizens might advance such concerns, in this case, ecological, in public policy, and nothing has worked. There is no plausible means or mechanism by which the extraction and burning of coal and tar sands oil from existing mines and fields can be halted on the timeline now required by any ordinary legal means. The letter asked the president to invoke his emergency powers to make the pipeline shut off permanent, to immediately phase down coal and tar sands extraction, and introduce a national mobilization plan to transition to renewable energy. These coordinated actions cut off 15% of the country's crude oil supply for a day. Reuters called it the biggest coordinated move on US energy infrastructure ever undertaken by environmental protesters. It resulted in the arrest of 11 valve turners, supporters, and journalists who now found themselves at the mercy of the state's criminal legal apparatuses. Of course, the valve turners expected this. The very notion of civil disobedience involves breaking the law, though the arrest of the journalists was a different and more troubling matter. But the valve turners didn't think that what they were doing was wrong. If anything, they thought their actions abided by the most fundamental principles of justice: protection of the common good, advocacy for the oppressed, and resistance to unjust authority. So they decided to carry their campaign to trial and to force the legal system to reckon with its own complicity. There was a useful legal strategy waiting for the valve turners as they sought to justify their conduct: the necessity defense. Over the course of the next few years, their courtroom battles would help to bring this strategy to the attention of the movement at large, and in time, make it an important legal weapon in the fight against fossil fuels. So what happens after this action, and what I was involved with as an attorney, along with a much broader and very impressive legal team involving Lauren Regan of the Civil Liberties Defense Center and attorneys in each of these states where these actions occurred, was a multi-state, multi-year effort to bring the climate necessity defense not only into court, but to make it a matter of settled law. Essentially what the necessity defense involves, and this is an ancient doctrine of English common law, is the breaking of a law in order to promote a higher social good. Defendants need to prove that even though they violated the letter of a statute, what they were doing was for the benefit of one person, the benefit of society at large, and so they should be acquitted. Typically, this involves proving that there was some sort of imminent harm, that there was no good legal alternative to breaking the law in order to mitigate that harm, and that there was a direct connection between the defendant's action and avoiding, mitigating whatever their targeted harm might have been. So in the climate change scenario, in a climate necessity case, these defendants need to convince a judge or jury that climate change is real, that it's a very serious, imminent threat. Perhaps most difficult, they need to prove that existing political avenues to addressing this change, existing perfectly legal mechanisms for dealing with climate change, have not been sufficient, and that their chosen mode of action, their chosen variety of civil disobedience, has a good chance of doing something about that problem. So the way this looked in the various valve turner trials was that we as a legal team had to present evidence to the judges and to the juries to try to convince them that this argument had been made. That evidence involved expert climate science witnesses, political scientists, a variety of commentators on climate politics and pipeline safety, all of whom we would hope would demonstrate, again, the severity of the harm and the capture of the political system by the fossil fuel industry. Now, unsurprisingly, given the general attitude towards civil disobedience and climate politics in the United States, and especially given the profile of some of these courts in more rural areas of the United States West, it was quite an uphill battle to try to convince judges to admit this evidence. And what we saw over the course of these trials in these 4 states was that in the initial stages, almost every single trial judge would reject the evidence out of hand, either because they thought that climate change was too controversial a matter to deal with in a criminal court, or most commonly, they didn't believe that civil disobedience was a rational way of trying to address climate change. There was lots of responses by prosecutors and judges saying, you need to lobby Congress, you need to run for office yourself, you need to send in more petitions. It's never advisable to go onto a pipeline site and shut off a pipeline, shut off a valve. Eventually, after several years, though, the legal team managed to hone its strategy. And in conjunction with the defendants, what we decided to do was to highlight constitutional rights over the very alarming facts of climate science. So rather than stacking our briefs at the outset with IPCC reports and descriptions of the imminent disasters that were coming our way, we decided to focus on a defendant's constitutional right to present a full defense, to go into court and describe their motivations and their state of mind when they took such serious action. Eventually, this tack seemed to work. So what I have on the slide here are 2 decisions that finally recognized the climate necessity defense and made it a matter of settled law in at least 2 states. First, in Minnesota, in the action that you saw on the previous picture involving Emily Johnston and Annette Clapstein, the Court of Appeals recognized their evidence, allowed them to admit it into trial, and in the course of their opinion said, if we're only looking at the traditional parameters of the necessity defense, this kind of conduct qualifies, and it's up to them to convince a jury that this actually was necessary. What ended up happening in that case, once we got that very favorable ruling, was that the judge actually threw out the prosecution's case. The prosecution's case depended upon showing that they had damaged a pipeline. And because of their very thorough preparation, the valve turners had never actually damaged a pipeline. They cut a padlock to get into the site, but everything they did to cut off the flow of oil was completely safe. No damage was caused to company property. The charges were thrown out. The opinion on the right is from the state of Washington, which, not in the valve turner cases, but building off some of their precedent, just last year, the Supreme Court again recognized the climate necessity defense as a matter of state law. So the connection that I see, at least, between the valve turners' action and this type of legal activism is that they managed to confront an infrastructural system that is enforcing the use of fossil fuels, both through the actual presence of physical infrastructure, but also the political and legal supports that allow that infrastructure to exist and to spread. They confronted that with their bodies, with a courageous act of civil disobedience, and pursued that action through many years of courtroom fights. And by earning judicial recognition of the climate necessity defense, they accomplished two things. First, there now is this strong legal defense tool that attorneys and activists can use to protect and promote this type of action. So if the valve turners analysis is correct, and that before we're going to see any proactive policy change for climate justice, we need movement building, we need people to take risks and to commit civil disobedience, then it's very important and empowering to have this kind of legal defense available to people who are contemplating such action. But secondly, what they accomplished by introducing this idea into the legal system is part of a broader effort to reflect the realities of climate science and the realities of climate justice in the transformations of the law. By realities of climate justice, I'm referring to not just the facts of global climate emissions and how we can link those to things like tar sands oil, but the need to reorient a lot of our thinking about relations between humans and their environment, the entitlements of corporations, the ways in which energy policy is legislated and planned out, all of which involve more social questions and justice considerations than the kinds of facts that you might, again, find in an IPCC report. In that sense, the climate necessity defense is part of this broader pushback against fossil law. If we consider fossil law to be the whole apparatus of regulations, statutes, and principles that keep this type of infrastructure in place. We've seen, again, lots of examples recently where there's this combination of grassroots activism and legal reform projects. This picture is from the efforts against the Line 3 pipeline in Minnesota, which crosses Ojibwe land, similar to the Dakota Access Pipeline in a lot of ways, part of this kind of business as usual expansion of fossil fuel infrastructure. Now, what has happened just in the last year in the resistance to Line 3 is a similar combination of mass civil disobedience and an attempt to make the law reflect the motivations and realities that inform that resistance. The Ojibwe defendants, at least in a lot of these criminal cases, have responded to the efforts of the state of Minnesota to prosecute them for civil disobedience by highlighting the role of wild rice in their protests. Wild rice is sacred to the Ojibwe. It's a means of subsistence and important in many cultural traditions and rituals. The new pipeline that's being built across Minnesota, if it ever leaks, poses a great risk to many existing wild rice areas. So what a lot of the Ojibwe defendants have done is that they've asserted that wild rice itself has rights. It is a legal subject unto itself. They cite treaties between the United States and the Ojibwe people to bring this argument. The United States has recognized that wild rice should be able to flourish in these areas. And in response to a criminal charge then, Ojibwe defendants will say, we were defending the rights of wild rice. Wild rice itself deserves consideration and respect under the law. And so we cannot be charged with violating laws on our own territory in defense of another vulnerable legal subject. This is a challenging idea to a lot of the fundaments of fossil law, which of course does not want to recognize any legal entitlement to anything that's not humans or a corporation, and challenges the notion that what is illegal is interference with corporate property or corporate business as usual in building pipelines, and trying to invert that presumption by actually saying what is illegal is the imposition of risk and fossil fuel infrastructure onto these stands of wild rice. To try to think about this a bit more schematically and put it into context of other things that I address in the book, if we think about what are some of these fundaments of fossil law, there's really a bundle of legal principles that support the continued existence of the dominance of the fossil fuel industry. So things like private property rights, which exist to protect fossil fuel infrastructure and the financial interests of fossil fuel corporations. Those are clearly a barrier to lots of attempts to democratize energy usage or to challenge the existence of dangerous fossil fuel infrastructure. Another key element is restrictive standing rules. So outside of some of the criminal cases I've been discussing, a lot of the challenges to legal advocates who are trying to address climate change through the courts is being able to get into the court in the first place. Some of you might be familiar with efforts like the Juliana versus the United States case brought by Our Children's Trust. There are also many suits by municipalities and counties against fossil fuel companies to try to address the public harms that fossil fuels have caused. And one hurdle that many of these advocates encounter is that courts do not consider their harms sufficient to get into court. They don't think that courts could provide an adequate enough remedy. And there's a variety of arguments that lead to the conclusion that courts have very frequently made that those who are complaining about the fossil fuel system don't belong in court. There's not a traditional enough conflict between a victim and a perpetrator to allow a court to litigate what they conceive as the broader issue of climate change. Then there are various matters related to what we might think of as corporate privilege, including what I mentioned earlier, the notion that corporations are persons, but many aspects of the natural world are not persons. These kinds of fundamental concepts that express themselves in particular outcomes we see in individual legal cases. Now, one thing that I think it's important to recognize is that lots of these ideas in and of themselves are not necessarily bad. One thing we have to grapple with as we're trying to overcome fossil law is the history of how these ideas have come to be our existing law today. Many of them, especially things like private property rights, were hard-won legal recognitions that came out of liberation movements in the late 18th and 19th centuries. Fighting for individual rights and rules of standing, the rule of law and legal process were important victories. But now we have to grapple with how those principles are actually implemented and are preventing us from moving on beyond fossil law to what we might think of as climate justice law. And here I've just listed some of the ideas that I try to engage with in the book, all of which I think are elements of a law that we might want to see existing in 2050, 2100. One way to think about this is, were we to have shifted our society to renewable energy and to be embodying some of the principles of climate justice in terms of doing justice to those victims of climate change and making sure that there is not the power of an undemocratic fossil fuel industry controlling our politics and controlling our energy usage, what sorts of legal principles would we have had to have adopted to have reached that point? I mentioned expansion of tort law. We already have lots of existing concepts that could allow us to litigate harm suffered by people at the hands of the fossil fuel industry, but we need to overcome some of the hurdles like standing that have prevented those cases from making a real impact. The public trust doctrine is the notion that the government or different sovereigns should protect assets like the atmosphere from private degradation. In the United States, at least at the federal level, we still lack any right to a healthy environment or to a stable climate system. This seems to be one of those entitlements that we should adopt if we ever want to see the kind of climate justice world we're aiming for. Similarly, rights of nature, as in the wild rice example, could be another way of bestowing entitlements. And the climate necessity defense, in order to pay attention again to how criminal law plays into environmental law, is another element that could facilitate this sort of transition. Now, I want to make clear as I kind of lay out these legal ideas, I don't think any of these concepts in and of themselves will be the primary agent of change. I think these are reflections of what activists and advocates are doing on the ground, and we need to try to extrapolate from them in order to construct an idea of climate justice law. But all of this happens within the context of inherently political struggles over the distribution of resources and the right to participate in the construction of a new world. We can think about the role of capitalism, the role of private wealth in preventing this sort of transition. So there's always, I think, a dynamic relationship between legal advocacy and other forms of political action, like direct action, mass mobilization. And rather than saying that the law or lawyers are going to lead the way, or that a judicial decision will finally give us the climate justice world we want to see, we have to always think about the dynamic relationship between those who are expressing certain legal ideas, maybe in different vocabularies and different language, and the actual type of legal practice that can promote them. Another important point I want to make before opening it up to discussion is that although a lot of the discussion in the book and in these brief remarks is focused on the United States, a lot of the energy for concepts like the rights of nature and environmental rights are coming from other parts of the world, especially Latin America, India, and New Zealand. So I think it's incumbent upon us to not only look at the development of US environmental law and climate law, but think about how indigenous groups, subaltern groups, different people who are more at the front lines of fights over fossil fuel infrastructure and climate justice, how they have thought about transforming the law, transforming entitlements and rights. And I think there's a lot of inspiration to be taken from some court decisions and constitutional provisions in places like Colombia and Ecuador that are at least sketching out what the law of climate justice in 2100, 2200 might look like. And so the point of focusing on a group like the Valve Turners is to try to see that law of climate justice embodied in almost a kind of anticipatory way. This is something we might think of as prefigurative law, people trying to embody today that new world that we hope to replace fossil law. And although we have some victories like the climate necessity defense or the slow expansion of environmental rights, there's still a gigantic uphill battle. And so part of the effort, I think, for us as legal thinkers, legal scholars, lawyers, is to simultaneously, to the extent that it's possible, try to advocate for clients, win concrete, discrete courtroom victories, while recognizing that it might take several losses, many years of sketchy thinking, judicial denials, living in the legal wilderness, before we start to see more of a synthesis of this new type of law. And ultimately, we need to keep paying attention to what else is happening in the world and have faith that this dynamic relationship between political action and legal advocacy will produce the climate justice law that we would like to see. So I'm going to stop there, and I hope we can continue the conversation.